Hi, so we'll be starting with lesson 12, securitization. Now, I'm sure you all must have heard, being in CS professional, what is securitization, since it's also there in your corporate restructuring subject. I just want you all to answer a few simple questions. First, which is the law that regulates securitization? In your CR, you all must be having that corporate restructuring subject. Which is the name of the act?
Surfacing.
Perfect. So the name of the act that governs securitization, we'll see what it means, but the act that governs it is securitization, that's SURFACE Act, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest. That's your SURFACE Act 2002. Now, in securitization, the security receipts or the instruments that are issued in securitization, they get listed on the stock exchange. For that, who will be the regulator when it's getting listed on the stock exchange? When a security is listed on the stock exchange, who is the regulator?
SEBI.
SEBI. Very good. So you have your SEBI public offer and listing of securitized debt instruments and security receipts regulations 2008. So these will be your two primary acts that we will be covering in this particular chapter. Is this clear? So the SEBI public offer and listing of STI and security receipts regulations 2008. Now let's understand the concept of securitization first. First, I'll read out the meaning as it is and then I will explain. Securitization involves the sale of debtors to ARCs, that is called as your asset reconstruction companies, who further raise funds and issue securities in this regard. It is a transformation of your financial assets into securities. Now, very difficult. When you read it, you don't easily understand. So first we will go to the graph to understand what it actually is. It's a very simple concept and we'll see. First, we are talking of a originator. Originator is a person who originates a loan, like a bank. Till here it is clear? Yes or no? They originate or they give the original loan. They give the loan to certain persons. Here we will call them as obligers. In simple word, we will call them as borrowers. Concept clear till here? So the bank has given a loan to the borrower. In return, the borrower will pay regular interest, yes or no, to the in interest and principal to the bank. Isn't this a normal typical loan? When the borrower takes a loan, he has to keep certain securities, yes or no? He has to keep some asset as security. So banks generally take secured loans. Now this is a simple loan, and for certain kind of home loans this is there, so we can also call them as mortgaged. It's a simple mortgage. Yes or no? I want you to simply say whether this is clear or no. Bank has given a loan, borrower has kept as security, and borrower pay the principal and interest. Till here it is clear?
Yes, sir.
Now you tell me, in the books of the bank, the borrower is an asset or a liability? For the bank, these debtors or borrowers are what? Asset or liability? For the banks, these borrowers are what? They are considered as assets. Yes or no? On the the banks on the asset side will consider that these are my debtors. They will keep paying me money on a regular basis. So for the bank, these obligers are financial assets. Now the bank gives a heavy loan of crores of rupees, but the interest and principal amount will come in parts in the form of EMI. It will come in the form of EMI. Now the bank has to wait for a long tenure to get the full amount. Am I right? Yes or no? So the bank might prefer to sell of these assets. They would prefer to sell the debtors to certain companies. Am I perfectly clear? So I might have a home loan which a person must have taken from the bank, and he's going to pay the bank regular EMIs. The bank realizes that they don't want to wait for so much time, or sometimes they are doubtful debtors, etc. So what does the bank periodically do to unlock these funds, to turn their illiquid funds? Sometimes there is a EMI default, etc. So these becomes illiquid. The bank prefers to sell their debtors to a certain entity. When they sell here, okay, the company to whom they sell is called as a SPV, special purpose vehicle, or they also call them as securitization companies, asset reconstruction company or securitization company, or here they will also call them as different terms such as special purpose, okay, entities, distinct entities. Concept clear? Now, and in India, the biggest ARC which purchases these borrowers from the banks is RCEL. And there are other SPDE as well. Now, when they raise these funds, okay, now when the SPDE is there, they will have to buy these debtors from the banks. They will buy a lot of debtors. So entire pool of debtors are sold by the bank to these asset reconstruction companies. Now asset reconstruction company, how will they get so much funds to buy these assets of the bank? Yes or no? So what do the asset reconstruction company or the special purpose distinct entity prefers to raise the funds by from the market by either listing the securities, how we make a IPO and raise the funds. So the asset reconstruction company can raise money from people. These investors could be qualified institutional buyers, investors, or it could be others who give funds. They subscribe to the securities of the asset reconstruction company, and in return the asset reconstruction company will give them securities. The name of this security is called as your securitized instrument, securitized debt instruments. Is this terminology clear? What are securitized debt instruments? When these securitization companies, they raise money from the investors, okay, they raising the money from the investors, they will have to issue some securities. The name of this security is called as securitized debt instrument. Now let's understand. So in simple words, let me get it here, okay. Now I'll draw a very simple diagram so you will understand. In total, can you tell me how many parties do you see here? How many parties do you see here? So first, there was a borrower. The borrower was in touch with the bank. The bank wanted to sell the borrowers to unlock the funds. So what they will do, the bank will sell them to special purpose distinct entities or asset reconstruction companies or securitization companies. They will sell them here, or also called as SPV, special purpose vehicles. So the banks sell these debtors or those borrowers to them. Now these raise the funds to pay the bank for purchasing these borrowers through investors. Now when the investors give money, in return they will get securitized debt instruments. Now in USA, the concept started in USA because what happened is in USA almost everything is on loan, everything is taken on credit. So they have lot of mortgage, all homes are almost on mortgage. So the bank gets regular EMIs, that's principal plus interest. Now sometimes the bank realizes that they don't want to keep and hold for so many years. The home loans are for 30 years, 40 years, 50 years. So they don't want to wait for so much time. So these mortgages, they would just want to sell it at a lump sum amount to the asset reconstruction companies, special companies, etc. So they will give the money here, and here they will sell their financial assets. Now financial assets for the bank is the borrowers. Now you tell me, very simple. Now I want you all to unmute and tell me. When I'm talking of a bank like SBI, okay, State Bank of India, they realize that they have lot of borrowers. They don't want to wait for so much time. They sell these borrowers to special purpose vehicle or asset reconstruction company. Now when they are selling to this asset reconstruction company, the asset reconstruction companies raises the funds through investors. When, like how we have debentures, the asset reconstruction company is raising from the investors. The investors are giving money, and on return on this securitized debt instrument, whatever principal and interest the borrower is going to pay to now they will pay to the asset reconstruction company. They will pay to the investors. Yes or no? The principal and interest will be paid to the investors. Obviously the asset reconstruction company will price the SDI at a very lucrative rate. For example, if they are getting from the borrower, they are getting 10%. They issue these kind of SDI at 9%. So what happens? The bank is continuously getting 1%. The special purpose vehicle will get 1% interest gain through this difference. Second benefit, now you tell me. As an investor, I am purchasing certain SDI, securitized debt instruments from these companies. I am paying the money and I'll say, what will I get? So the SPV, the special purpose vehicle or the securitization company will say, don't worry, whenever the borrower pays us, we are going to further pay you interest and principal amount on your investment. So investor is saying, okay, fine. Then the investor is saying, what about security? You have issued me a securitized debt instrument. What if money is not paid? What if there is a default? What is my security? I want you all to unmute and tell me, will the SPV mortgage or the SPV mortgage its own securities, or they will say that, listen, we have in the back end, we have a mortgage, the borrower's assets are kept as security. You tell me, will the securitization company give new security, or they will say the borrower's security only is kept as your security? So what we will tell the investors, don't worry, give us money. Okay, with this money, we will buy all these data from the banks. We will get regular income, and then we will, from whatever that it is there, our expense, our profit, etc. Then we will give you. And these are the terms of the issue. The investor will then also say that what is the security? So I'll say the same security. If the borrower doesn't pay, we will sell the security of the borrower. That whatever money we get, again it will be distributed among all of you all. So the security will be of the borrower only. Concept perfectly clear? Yes or no? So what happened So what happened is the financial assets which were of the bank. For the bank, the data are financial assets. Yes or no? For the bank, the borrowers are assets. What did the bank do? Bank sold the financial assets. Financial assets, here I'm talking of debtors. They sold the financial assets. So the bank sold the financial assets, that the debtors, to SPV or securitization company, all different names, asset reconstruction company or special purpose distinct entities. Now these in the back end raise the money. These in the back end raise the money from whom? From investors and QIB. Concept clear? And the name of this security is STI. What is the security? Is a borrower security and assets. Concept perfectly clear, yes or no? Yes or no? Is the concept clear? So
can you please again repeat the same what you have said just now?
Okay. Yeah. So I'll explain. First, very simple concept. Understand the structure. First leg of the transaction is this. Where have you all ever taken a home loan, or you know anyone who's taken a home loan? Yes or no? I want quickly to just be responsive so it'll be faster for me to explain.
Yes.
Yeah, we've heard of mortgage loan. So this is the first leg of the transaction where a bank has given a loan to the borrower and the borrower has kept his asset as security.
Yes.
Now you tell me, if I'm talking of, this is the SBI, State Bank of India, and they have lot of borrowers. They have given loans to many people. Always will SBI want to sit till maturity period to get all this money?
No.
Home loans are for 30-40 years. So these are,
yes,
money is locked. I am getting the gains, but the money is locked. I'm getting in parts. So if I am sitting in the bank and I want to unlock these locked funds, what is the best thing I can do?
I can sell. We can offer the sell to unethical.
Correct. So then we will say that, listen, we are going to get 200 crores on these debtors. If someone is ready to buy it for 150 crores, please give it to me. So there are these companies in the market who purchases these home loans, who purchases these debtors, who purchases these financial assets from the bank. Concept clear?
Yes.
So now what will happen? The second leg of the transaction comes where the bank requires money. So the bank will sell these financial assets called as debtors to these SPV. Now this is the second leg of transaction. Concept clear?
Yes, sir.
Now comes the third leg of transaction where will these SPV get the money to buy? Because when it is sold, it is not sold for 2-3 crores. They are called it as asset pool. Asset pool is what? So many borrowers of the bank of SBI are sold, and it might be 300 crores, 500 crores, thousands of crores. So don't you think the SPV has to arrange huge sum to buy these assets?
Yes, sir.
So then let's say we are in the SPV now. The biggest SPV in India is ARCIL, Asset Reconstruction Company India Limited. It's the biggest ARCIL. They go and they buy from all these banks. Now ARCIL is sitting and thinking, ARCIL is sitting and saying, how do I raise? I'm getting a good deal here. The banks is giving a good deal to me, but I require 2000 crores. So then they will say, what do companies do when they need funds? Huge amount of funds.
They will approach the investors.
They will approach investors. They will make public issue. They will inform investors that, listen, there is a good deal out here. We will make XYZ percentage returns. It is a very, very safe investment because the borrowers, bank also have taken money from borrowers and the borrowers have given good security. So home loans are very secure. So even if the bank is secured and the SPV is secure, that means the investors are secured. So the investors will also say, we are getting a good deal, 9%, FD we get 6-7%, here we are getting 9%, and these are very safe. Why? Because it is in USA they call it as mortgage-backed securities, because these securities are backed by mortgages. So these are called as mortgage-backed securities. These securities, when they issue, so when the SPV is going to issue securities to the investors, it has to have a name, right? To identify that this is a specific type of company, that it is backed by mortgages. Yes or no? In the market, we should come to know, na, this is what it is. So we give it the name of securitized debt instruments. And this company can also be called as special purpose distinct vehicle, etc. Concept perfectly clear?
Yes, sir. Correct.
Yeah. Now let's go through the module. Once this concept is clear, then it becomes a cakewalk. Okay, and we'll be going very fast on this chapter. Okay. So let's start. Now tell me whether this same line which I'm reading, do you understand it or no? Securitization. Why do they call it securitization? Because the financial assets which were there, the debtors, have now been sold in the form of securities. So different securitized debt instruments will be there. Investors have invested. As the borrower will pay us money, we will pay to the investors. If the borrower defaults, we will sell the asset, and then the whatever from the assets we will get, we'll give it to the investors. Concept clear? So I want you all to unmute and tell me whether you understood this or no. Securitization involves a sale of debtors to asset reconstruction companies. Yes or no?
Yes, sir.
Yes. Who further raises the funds to purchase the securities by way of issue of securities? Yes or no? Now,
Yes, sir.
securitization is the transformation of a financial asset that is debtor into securities. Now, securitization is used by financial entities like banks. Can NBFC also do the same thing? We know banks can sell their debtors now. Okay. Can NBFC is also non-banking finance company. They also give loans, etc. to purchase certain assets, etc. Can a NBFC also sell their assets and enter into the securitization process? Yes or no?
Yes, sir.
Answer
to raise
is
the fund, they can.
very good. So they can. That's why they've called it as financial entities. Okay. Now they can raise funds otherwise than what is available by the traditional methods or on balance sheet funding. So other than keeping their debtors as security and taking a loan than the traditional method, the newer type of methods are selling the entire headache to the asset reconstruction company. So it's a technique to use to convert the illiquid assets into tradable form of securities. Concept perfectly clear? Yes or no? Quickly. Yes or
Yes,
no?
sir.
Yeah.
Yes, sir.
Very good. Okay. Now, the steps involved. 4 steps are involved in securitization. First is there is a special purpose distinct entity is created to hold title of the underlying securities. Now again, first 4 steps. First you tell me you understood 4 entities or no. The special purpose distinct entity is created to hold the title of the assets. Means what? First there is a bank. This bank wants to sell the debtors to the company. The name of the company that we will be using instead of SPV, securitization company, what term we will be using? SPDE. Clear till here? So first step is to create a SPDE. Yes or no? The first step is to create a SPDE who will hold these assets and perform all the securitization process. A yes or no?
Yes.
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 Second, they are calling the bank as the originator. Who's the bank here? Originator. What do you mean by the term originator? So they have originated the loan, they have given the loan. So the bank gives the loan to the borrowers, and the borrowers are called, anyone can recollect what do we call as the borrowers?
Obliger.
Perfect. We call the borrowers as obliger. So the obliger is obliged to repay the loan and the bank has originated the loan. Okay. Now the originator sells the assets to the SPDE. Agreed or not agreed? Now SPDE, with the help of an investment banker, issue of securities are distributed to the investors. Now obviously the SPDE will have to hire certain professionals to further make a public issue or a private placement, but they will have to reach out to investors. Okay, so the SPDE will issue securities. They will issue securities to the investors, and same concept like how the borrower had to pay to the bank, he will now pay to the SPDE and the SPDE will pay to the investor. Concept clear? Yes or no?
Yes.
Yeah. So we can say that when the investor gave the money to the SPDE to buy these assets, okay, from the financial assets, the SPDE will have to issue some security. What is the name of that security? Quickly, that is the term we will be using.
Securitized debt instrument.
Perfect. It will be called as securitized debt instruments. For the investor, this will be like a bond where they have invested the money and they will get principal and interest as the borrower pays. If the borrower defaults, the assets are sold and we will get the money. So we will just be in the position of bank. The SPDE, after cutting its expenses, its profits, then transmits the money to the investor. So this is how the business works. The SPDE pays the originator for the assets with the proceeds from the sale of securities. Concept perfectly clear. From the selling of securities, SDI, the investor will give money to the SPDE. The SPDE will give to the money to the bank, and then the bank will sell the debtors. Okay. Moving forward, this is the concept we had explained. Very simple. Now I want to understand from this your understanding. When this structure is made, the borrower is here. Let's say I had taken a home loan. So this is me. I'm drawing myself. Okay. Now I'm a simple borrower. First, I used to pay to the bank. Yes or no? I used to pay my principal and interest on time. I like to pay my whatever obligations are there on time. After the background structure changed, do I have to pay to SPDE or do I have to pay to the investor? Now I'm wondering, who do I have to do? Quickly, what do you think? The borrower, obliger, will now pay whom? Bank? Come on, I want you to tell me, will I pay the bank or will I pay the SPDE?
Borrower has to pay to bank only, not SPDE.
Now the point is very, very important that it will be decided between the parties. I have to pay. First I will pay bank or I will pay SPDE. If SPDE says pay continuing to the bank, and then the bank will appoint, they use certain terms as servicers. Servicers are those who will collect, ensure that the money is given, all this collection and all of those. They are providing various services. For the borrower, I will be told. It is not necessary that I will have to pay to bank only or have to pay to SPDE only. I will be informed. If in the background the SPDE says don't trouble the investor, because how will I change my bank accounts, right? If you ever taken a home loan, you have to pay in one particular account. If that account is changed, don't you think there will be a sequence? There will be some continuity of record will be a little difficult. Anyone doesn't like change. It will create so many borrowers. To everyone will ask, what does securitization mean? Don't you think borrowers will keep asking? What do you mean what securitization? I don't so then we say, listen, the bank and the SPDE will decide that, listen, this is the most smartest thing to do. Let's do this. So generally, they do not trouble the borrowers. They tell the borrowers, keep paying the bank. The bank will have these servicers who will further route it to the investors. Concept clear, SPDE and investors. So this is what they've given you on the RBI site also. See, continuing flow of funds from the obliger here is the borrower, to the SPV is routed through the originator only. It is routed to whom? Routed through the originator, that is the bank, in its capacity as an administrator. And now the bank will have become just like an administrator or a trustee, or will have to hire someone who will route it to the thing. However, if sometimes bank will say, listen, I don't want to do any of this, I don't care, I want my money and I want to exit. You deal with all these issues, administrative issues, give a notice, whatever you want, I want to be out. So then we say, okay, fine. On the other party appointed of the SPV can also perform the role. It is also possible that the SPV receives the amount directly from the obligers. Concept clear? So anything is possible. Yes or no? Now again they will repeat the steps, but I will go a bit faster, and I just want you all to keep saying, yes, we've understood. Steps in securitization. The first step is when the SPDE acquires the acquisition of the financial assets. So the acquisition of financial assets by the securitization company from the originator. Concept clear? Here the financial assets are backed by proper properties. In USA, what do they call this? The same concept, what we call as SDI, what do they call it? I told you all. Quickly unmute and tell. Mortgage-backed securities or asset-backed securities. Because these securities are backed by certain collaterals, by certain home loans or whatever loans security has been kept. So the financial assets are loans backed by properties. So the originator is the bank who has lent the money to the original borrower. The SPV issues security receipts which are distributed to the investors, and the SPV pays the originator with the proceeds of the receipts of sale received from the investors. Parties involved. How many parties are there? Bank, borrower, SPV and investor. Concept clear? Now sometimes we also have rating agencies that are there. So whenever I don't know whether you all know it or no, if you are making a public issue, a credit rating is taken by companies, yes or no?
Yes, sir.
Yeah, credit rating is the financial assessment of the company, how good it is, whether it's a 5-star, whether it's 3 stars, AAA rated, AA rated. So investors come to know the credit worthiness of the company, the value and the how good is the company. So even here the SPDE will, since it is raising money from public, they also have to get credit ratings done. Now we are coming to the background genesis, the background. Okay, very simple. So biggest country you could say or is your USA. They were much more advanced. So what happens? Securitization has originated from mortgage markets in USA. In mortgage markets, the USA, obviously any bank, when they used to give residential loans, home loans, so then they started saying that these home loans we want to sell, and then they used to sell to certain entities who used to raise the money from investors, and they used to be called as mortgage-backed securities. Didn't I tell you this? So these are the residential mortgage-backed securities, and it was introduced by Ginny Me in 1970. Next, other US government agencies, also jumped into this concept. Now first, we've always heard of mortgaged backed securities. Now, even apart from the mortgage market, even outside the mortgage market, where we are saying not home is not kept, it's not a mortgage. Maybe if my company then, now pay attention to this, very important, because it's not always banks. Anyone who's interested in selling their data can do that in this concept. Means if I am a company and I sell certain assets which are sold on credit basis, on basis of they will keep paying me because some machineries are heavy machinery, they are paid. So even I can sell them, yes or no? But these are not mortgages, these are my datas. So they said that the first securitization of receivables, these were my receivables, outside the mortgage market happened in 1975 when Sperry Corporation securitized its computer lease receivables. Okay, so in USA, computer lease were there, or maybe I've sold my computers on certain lease and I have lot of credit data on my books. I can reach out to these investment companies and sell. Now further, it was so we saw mortgage-backed securities and also non-mortgaged, like your receivable have been kept as securities and it has been done. Now this was about USA. Then they also said European securitization did not start up until the early 90s. Okay, but thereafter followed a similar track to that in the USA. So they also followed. Now coming to India. In India, it came in early 90s, but it for 20 years, 2 decades, securitization market continues to be in the early stages. It continues, it hasn't grown that much, but now if you see, it's a very common and a developed market. For securitization to cover all kinds of securities, can anyone please unmute and tell me that when securitization companies issued these kind of securities, what are these securities called?
SDI.
Yeah, securitized debt instruments. Okay, now they said that the SCRA Act, the Securitization Regulation Act 1956 was amended, and they said that the term securities shall also include securitized debt instruments. Concept clear? So whenever they come with management, it even covered securitized debt instruments. Now all this is regulated under 2 acts, as I told you. Securitized debt instruments are regulated under the SARFAESI Act 2002 as well as the 2008, the SEBI public issue of SDI and listing 2008. Both we will see. Now, the first securitization deal in India was between Citibank and GIC Mutual Fund in 1991 for 160 million. Now again, which I told you, initially the SEBI issue and listing of SDI regulations 2008 was applicable to public offers of SDI and also listing. So these regulations 2008, okay, for securitized debt instruments, what do they cover according to you? If I tell you SEBI, any regulation concerned with SEBI, don't you think it is talking about listed companies? Yes or no?
Yes.
Yes. So first it covers public issue. What are the rules, etc.? What are the regulations for public issue? And how do you get yourself listed? Okay, we will see that in the later part of the chapter. Now, they are defining what do you mean by securitized debt instruments, and I'm sure you perfectly must be understanding. So if I'm reading this definition, you should understand it. Securitized debt instruments has been defined to mean any security, any instrument or any certificate. That debt instrument is any certificate issued to an investor by a SPDE. So the SPDE is issuing it to the investor, where which possesses any debt or receivable. That means when I'm issuing this, it means that it is issued backed by certain mortgages. It is issued, but there is a receivable on this, and then I'm issuing it to you. So there is a receivable assigned to such entity, acknowledging the beneficial interest of the investor. First, the SPDE has been assigned this datas, yes or no? The SPDE has been assigned, that is certain datas have been sold to me, yes or no? Exactly, that will be written in the certificate, that the SPDE possesses any receivable, okay, which has been assigned to me, and I acknowledge the investor's interest that he is paying me, I have to repay him, etc. In the budget speech, the finance minister announced that listing and trading of securities issued by securitization or reconstruction companies under SERFISI to be permitted in SEBI. So we are seeing in 17-18 they said it should be permitted on recognized stock exchange. Pursuant to that, when the finance minister said, SEBI set up a specific committee comprising of representatives from RBI, from credit rating agencies, from law firms. So entire committee was set up of merchant bankers experts. Now what was the conclusion and what was the outcome of that committee? So based on the recommendation received from the committee, chapter 7A was introduced in the SEBI Public Offer and Listing of Securitized Debt Instruments 2000 Amendment Act, and the regulation name is SEBI Issue and Listing of SDI and Securitized Regulations 2008. So I want you all to remember and quote in the exam if it comes the chapter name. What is the chapter name that has been introduced and which we will be studying later also? So SDI, but we should know what law is behind that. So chapter 7A of SEBI Public Offer and Listing of SDI Regulations 2018. Concept clear? So chapter 7A we will be studying. They've given you the definitions, etc. Now a very simple part they are asking, how did this concept of securitization gained importance? Now it is for understanding purpose. Okay, so I'll explain in short, you will understand it immediately. Nowadays, banks, when they are giving loans, there are chances of bad debts. Yes or no? There are chances of defaults. Yes or no? Imagine if a big borrower has defaulted, the entire bank can be destabilized. Yes or no? If the bank is destabilized, the depositors, where you and me deposit our money with the bank, our money can be hit. So the entire economy can be hit, and the confidence in the banking system can be affected. Yes or no?
Yes, sir.
Yes. So what they are saying, that listen, that when this gets affected, the entire economy can come down, banks can come down. So securitization is a very good step where the bank can unlock these locked funds and sell the assets. So when borrowers make any default, it causes an economic cost to the nation, and banks are generally stuck up in these locked funds. So, and if there is a default, the public at large can be affected because the main source of funds of the entire people are in these banks. So therefore having the securitization is a very good concept, okay, where we can unlock the funds for the bank. Now this, I think you all have correctly answered. Is SERFISI Act applicable to NBFCs? Yes or no? What did I tell you all?
Yes, yes, sir.
Answer is yes. Also what earlier happened is government had put a limit that only up till this limit, below this limit you cannot come to, NBFCs cannot come under SERFISI. So that limit was also reduced so that more types of loans can come here. So let's read it out what it was. So the Ministry of Finance in 2020 notified that NBFC with the asset size of 100 crores or more are eligible. So big NBFCs of an asset size of 100 crores or more. Obviously that is a very minimal amount, 100 crores, okay, or more in this sector. They can enforce their security, they can get the money, etc., and they can use the SARFAESI Act when the debt amount is at least 20 lakhs. Earlier the limit was how much? 50 lakhs. It has been reduced to 20 lakhs. So what happens if I am an NBFC of 100 crores or more and there is a default of 5 lakhs? Can I use SARFAESI Act? Yes or no? 5 lakh default. Can I use SARFAESI Act quickly?
No, sir.
No. Minimum default amount should be of 20 lakhs. Then only I can use the provisions given under SARFAESI Act. Okay. This is what they have given, and they have explained about SARFAESI Act, what all the act is about. That in SARFAESI Act also you can give a notice to the defaulter. For example, if a borrower has defaulted on my loan, the bank can give a notice of 60 days. Okay. 60 days notice will be given to the borrower that repay my money, otherwise I will exercise my right of selling. I will enforce my rights. I'll sell off your assets and I don't even have to go to court. That was the SARFAESI Act. Okay. So this gave a lot of powers in the hands of creditors, where the creditors, if their money is not repaid for 60 days, they'll give a notice and they'll say pay me in 60 days, otherwise I will start selling the assets and I don't even require order of court. So this became a very strong power in the hands of creditors, and NBFCs can also use this power. We saw the limits that was given. Now remember I told you all, with the concept is now perfectly clear. Now coming about listing, issue and listing of these securities. First, what is the name of the act that covers the listing of these securities? It's your SEBI Issue and Listing of Securitized Debt Instruments and Security Receipts Regulations 2008. Okay, it notified them. It was notified on May 26th 2008. When all it is applicable? So very simple, from the name itself. What was the name? For public offers of SDI and for listing of SDI. Yes or no? Yes or no?
Yes, sir.
Yeah. And when I say that these investors are there, does it always have to be public investors and public issue, or it can also be private placement? Quickly. It can be privately placed also, or it has to be public issue only?
It can be both, sir.
Very good. Why a public issue, a public company cannot make private placement? Obviously, a public company can make a public issue also, that is raise money from public, and if it wants to privately give it to certain investors, that also can be done. So same, this act is covering not only public issues but also privately placed to QIBs. Concept clear? So they can privately place it to qualified institutional buyers. So these buyers are institutions, could be a mutual fund, okay, that wants to purchase these kind of SDIs. So investors could also be these QIBs. So this act covers public, private and listing of SDI. Moving forward, eligibility. Now eligibility for what? Let's read. First, if one wants to make a public issue, a person cannot make a public issue of SDI unless, if you want to make a SDI, what was the first step we read? That there has to be a creation of what?
SPDE.
So very good, you have to constitute a SPDE and comply with all the provisions of these regulations. Now, the requirement of obtaining, now again, very, very important. Remember, I'd used the word certain servicers or trustees also have to be appointed. So here we will see, first you have to obtain you have to be, and all the trustees are registered with SEBI, okay, under the Securitized Debt Instruments Regulations 2008. So very important. 2 points are there in this A thing. First is you have to constitute a SPDE, and the second point is you also have to appoint trustees. Trustees who will look after, like how we have you heard of debenture trustee?
Yes, sir.
When we take loans from public, we are giving them principal and interest to ensure that we give it on time, security is kept properly. Government has said that you appoint trustees who will protect the interest of the investors. Same way here also they are saying that it is also a debt instrument. Here also you appoint trustees. Now these trustees have to be registered with SEBI under which act? Quickly. This SDI Act, yes or no? However, they said that if it is already registered under some other act as a trustee, for example, they are registered under the Companies Act as a debenture trustee, then again they don't have to require registration under this act. So the requirement of obtaining registration is not applicable for the following persons. A debenture trustee already registered with SEBI. Will we tell them to be registered here also as a trustee? SEBI is saying, okay, fine, we know you're a trustee, whether you're a debenture trustee or SDI trustee, doesn't matter. If you are already, registered with RBI, so any person registered as a securitization company with RBI or a NHB bank, okay, National Housing Bank, or a National Bank for Agriculture and Rural Development, any scheduled commercial bank, any public financial institution, any other person specified by SEBI. So SEBI at the moment has specified all these persons. If they are already registered, they do not require a separate registration as a trustee under the SDI regulations. Concept clear? Now, an application seeking registration to the trustee, okay, as a trustee. Now, if I want to become a trustee under the act, how much net worth do I need to have? Answer is 2 crores, and I require minimum 2 persons who will be there who should have at least 5 years of experience. Next is launching of schemes. Now understand, can anyone tell me who is going to launch schemes to whom? So then I will tell you the details of it, but I need this to be correct. Who will launch the investors to whom? Who will launch the schemes to whom?
SPV on the scheme to the investors.
Very, very good. So the SPDE will launch various schemes, because we see whenever IPO comes, there are different kinds of IPO, there are different schemes given in that, different terms, etc. So then schemes will be launched. So they will launch schemes, offer documents, they'll make it very interesting so that investors will want to invest. Now schemes can be one scheme or they can have multiple schemes.
Multiple schemes, sir.
Multiple schemes, because the loans could be of multiple types, multiple tenures, multiple time zones. Okay, so they will launch different schemes, and then the investors will say, okay, fine, I want long term, I want short term, I want this security, I want that security. So multiple schemes can be launched. But you tell me, so the first thing what you said is perfectly there. Launching of schemes. A special purpose distinct entity may raise funds by formulating, developing, creating, launching schemes. Multiple schemes can be launched, but do you think they will have all one bank account only? They will never mix the funds. For one scheme, they will have one account. Yes or no?
Yes.
Obviously, because one scheme is there, they will have a different redemption date, they will have a different interest rate, they will have different backed securities will be different. Okay, there will be different terms and conditions. So this account will be different, this account will be different. Okay, you shall ensure that the realization of the debts and the receivables are done on time. The SPDE and trustees once they get the money from the investors, you think the trustees and the SPD can go to sleep and say, wow, we got money, we raised money, or they will have to take steps for collection from the debtors? Don't you think proper realization of debt should be done? So as a trust, I have to collect the money and then ensure that I give it to the investors. Next, the terms of the SDI may also provide for a cleanup call option. They can also provide for what? A cleanup call option subject to adequate disclosures. Now let's understand what is the meaning of cleanup call option. If you have taken a loan, you have to pay interest and you have to pay principal. Yes or no?
Yes, sir.
Now, imagine if very little amount of the loan is left. Wouldn't you want to premature close it?
Yes.
Anyone will want to close before the maturity period. It is a very good situation that you want to close the loan before the tenure. But this loan you cannot close when it is 90% of the amount is remaining. Yes or no?
Yes, sir.
You will be able to close the loan where very small portion of the loan is left, and you will say, okay, great. When it is, they will give you the thresholds. It will be mentioned. Okay. And generally the threshold limit is 10%. If only 10% is remaining, then the SPDE will have an option that all the investors who have given the money, we have to redeem the securities, we have to pay them interest. So we can clean up the entire scheme and we can close it down by early redemption. So in simple words, what does this mean? Early redemption. Okay, so that will also be told why and when, in what circumstances this early redemption can be done. No expenses shall be charged to the scheme in excess of the allowable expenses. Obviously, what has been allowed, only that much allowable expenses I can do. So cleanup call option is where the SPD is ready to buy out the securities early. So it is a early redemption of the entire balance of the debt instrument when a relatively small amount of original issue is outstanding. Concept clear? Concept clear? Yes or no?
Yes, sir.
Yeah. Now next is obligation to redeem securitized debt instrument. What does redeem mean? We spoke about early redemption, but what does redeem mean? What does redeem mean?
Repayment, sir.
To repay. So the investors have given us money. It is in the form of a loan only, where we have to repay with principal and interest to them. Now they have given us money. Now when they have given us, we have to redeem. We also will have a maturity period. We will also have to repay. So it is a duty of the SPDE to repay to the investors. Okay, on time. And we should how we will be able to repay? Only if we collect the money from the back end correctly. Yes or no? So proper measures should be done to recover the dues from the obligors also. From the borrowers, I will be able to I should take proper steps to collect and then repay. Now ensure timely payment of interest and redemption to whom? To the investors. And how will I be able to do? If I collect from my obligors are the borrowers. If I collect from the borrowers, then I will be able to pay to the investors. And expected period of maturity of each scheme, okay, should be disclosed. If I can premature close it, extend it, etc., all that. Maturity will be there of the scheme. Investor is giving the money, he will know that it is a 5-year period. Like how we have 5-year bond, it is a 5-year. After that, I will get all my principal back, and in between, I will keep getting interest also. So if they want to roll over, that is extend the scheme, or they want powers to early redemption, all those proper disclosures should be there. Then, you think the directors will go to collect and call the borrowers, pay the money, give me the money, You think the borrowers and directors and promoters will do, or they will hire servicers, or they will avail services of an entity? Yeah, what will they do?
Avail the services.
Yeah, you think the promoters will call up the borrowers? All different promoters are calling and shouting at different borrowers that pay the money. Answer is no. There is a professional collection recovery agents. They do the job. So a SPD may appoint, either, as we saw, we tell the bank only that you only collect as you would have collected. You have a collection team, or we can hire any other person as a servicer. Now, what services they will give? Trustee services, who ensure that the proper accounts are kept. Okay, the trustee shall ensure that the servicer keeps proper accounts. So the trustee should ensure that the accounts, the services are these workers who will ensure that the proper accounts are kept. The trustee shall ensure that the servicer has proper operational system, resources to administer and control this asset pool. What does asset pool mean? The bank has sold us one mortgage, or you think they must have sold us a pool of mortgages?
Pool of mortgages.
Obviously, the bank, they pool up all that they have and then they sell it off. So now to manage this entire asset pool also we require proper operations, proper recovery team. All of that will be done by the servicers. The servicer may be appointed to do all or any of the following: coordinate with everyone, the borrower especially, administer the asset pool, and once they collect, to distribute to the investors, and manage the incidental manners. When SPD appoints the originator as a servicer, now we are appointing whom? The SPD appoints the originator as a servicer, which is normally the case. We tell the bank only, his recovery team, that you continue as if it was your loan only, just collect and give to us. Then proper internal procedures should be maintained to avoid conflict of interest. So then you have to ensure that there is no conflict between the SPDE and the originator. They are only ending up fighting, why you didn't collect, you are not interested. All those things should not happen. Now, please can you tell me who has sold the loan? Who has sold the debtors? The bank. Okay. Now, when they have sold it, don't you think the bank should now get away of the transaction? They got the money, now they should leave.
They will not, because they are the originators.
Correct. So they have originated by giving the loan. After that, now they should just become like the administrator, right? They just collect and give. The bank sold it. Now the bank should not interfere a lot. Here what they are saying, the SPDE is trying to raise money from the investors. Can the bank only become the investor by purchasing securities?
Yes, sir. No, sir.
So they will say, what nonsense are you taking? Are you trying to do fraud? You're creating a circle. You think we are fools or what? See what is happening here. Understand. The bank sold it to whom? Please tell me, it sold to whom?
SPDs.
SPDE. SPDE is raising money from whom?
Investors.
Investors. Can the bank only invest?
No, sir. No.
So what will happen is, they'll say, what is this loop going on? The SPDE, the asset, the bank sold to SPDE, and now SPDE is raising funds from investors. Okay, they invest. And how are they getting the money if the bank is only investing? So does this transaction seem valid, or it is a fraud? Quickly.
It will be, because already bank has given as a borrower, they cannot block their fund again for as an investment fund.
Correct. So what is the scenario? This is what they're saying. The SPD is going to pay the bank. So the bank is now only investing. So they say, wait, this loop cannot happen. So the upper limit has been put. What has been put? What has been put? Upper limit on how much the originators can subscribe to these assets. Because see, these are all debt instruments. SDI is a debt instrument. Now the bank has sold it, but later they want to buy from secondary market, etc. They will say, it was a good transaction, we did a mistake, let me invest again. So they say, no, now you cannot. Holding of originator. No originator shall subscribe or hold to SDI in excess of 20% of the total SDI issued by the SPDE in a particular scheme. So what is the maximum holding that they can have?
20%.
20%. Okay. So the bank will say, my wish here, I'll invest wherever I want to rotate. So they say, listen, SEBI laws are there, maximum 20%. This applies only to instruments which are offered to public. So when it is offered to public, only then it is applicable. No originator at any time should subscribe or hold in excess of 20% of the total debt issued by the SPDE if it is a listed entity and the holdings are listed. Clear till here?
Yes.
But it will not apply if the originator is acting as an underwriter. Nothing shall apply to the holdings of an originator acquired on an account of a underwriting of the securitized debt instruments. Now let's understand. Now they have acted as an underwriter. Let's understand what is this scenario. Imagine the SPDE was very scared. SPDE was what? When exams are near, what you also feel? Quickly. Nervous, anxious, scared. So same way, SPDE was very scared. They said that, listen, if I am buying and if imagine public does not subscribe and I have entered, what will happen? So what is happening is the bank is saying, don't worry, my loans are good. You go make a public issue. I am giving you the rights. Make a public issue. If there is under subscription, balance amount I will subscribe. I will remove from my pocket. Understood? The bank is guaranteeing that don't worry, go to sell. It will be sold like hotcakes. People will come. Oversubscribe will happen. Oversubscription will happen. You just see. And you saw that nobody came. You will get a shock of your life. That I have entered into these transactions and nobody is subscribing. Investors are not coming. So the bank can give a cushion to the SPDE and underwrite a certain amount of shares. Clear till here?
Yes, sir.
Bank wants to get rid of its loans and they will do anything for it. Okay. Now, so then that time if they are buying pursuant to this, then they will say, okay, fine. Maybe they could not sell off 100% they are holding. So this time the limit doesn't happen if you are acting as a underwriter, provided that the possibilities of such holdings are disclosed in the offer document. So everything should be disclosed. Should we maintain records or we should not maintain records?
We should maintain the records.
Obviously, maintain a register of the records of the SDI. If people are buying through DMAT online, or we can say a DMAT account through your trading app, then you will be called as a beneficial owner and your name will be mentioned with the depository, right? So that also can be done. Either you have physically bought and your physical documents are getting, or online. So either of that, you are a shareholder, you are a stakeholder. SPD shall intimate to SEBI where the records and documents maintained and the accounts maintained are kept. The SPD shall maintain its books of accounts a minimum period of 8 years. So they should preserve the books for how many time? For a period of 8 years from the date of redemption of all the instruments. So I have paid off everyone, then for the next 8 years I should preserve it. Once I have paid everyone, then what will happen to the scheme?
We'll close.
We will wind up the scheme, we will close down the scheme after it has been fully redeemed. When the scheme has been fully redeemed, can I say it was a success? Yes or no? And the investors will be happy or sad? Investors will be happy. But is there a situation that they might not give? If we're talking about happy, you should also talk about bad. So, if upon the legal maturity, there is still outstanding amount, okay, then the trustee shall dispose of the same in accordance with the scheme and distribute the proceedings, okay. So, here is a sad ending. It's a sad ending where the legal maturity has come. It has come, the due date has come, but still we could not repay, and there was some amount of outstanding debt, that there was still amount we have to repay. Then the trustees will take measures to, repay whatever by selling off any of the assets. Concept clear?
Yes, sir.
Scheme can also be wound up by passing a special resolution among the 3/4 of the investors saying, now stop this scheme, give us some money back. Now coming to a public offer. First, now two last points are there that we will be doing, two topics. One is public offer of SDI can be made, and another one is what? If a public offer can be made, what is the other one?
Private.
Perfect. Private placement to QIB. So first we will see public offer and listing, and then we will see private placement and listing. Concept clear?
Yes, sir.
So let's see. Offer to public. No offer shall be treated as public if the offer can be properly regarded in all circumstances. It is not likely to result in securitized debt instruments becoming available for subscription by any person other than those who are receiving the offer. Okay. Simple. Very complicatedly they have explained very simple concept. So when they are using this term, these words, they are saying that this is a public offer or private. Quickly.
Private.
Public or private? Read and tell me. These two things they are saying is public or private? Please unmute and tell.
Other than those receiving the offer, that means the private.
That means private. Very good. So see what they are using the term, no offer shall be treated as public if, means these will not be treated as public. They will be treated as private. So no offer shall be treated as public if the debt, so these are private. That means I am offering it to a person and to no other person. So the securities are not likely to result in available for subscription by person other than those receiving the offer. So in private placement, we know to whom we are giving, and if we are giving to them only and no other person can subscribe, then it is a private offer. Concept clear?
Yes, sir.
Yeah, this part you can cancel, even this. Okay. Now, simply these 2 points are saying if you are giving it to a relative entity or domestic concern, that is a connected entity, still it will be a private placement since you are not giving to others. Only the A point is important. Any offer made. Now when I say private placement, I believe you must be knowing the rules for private placement. Can I make it to 50 persons or more?
No, sir.
No. If you make it to 50 or more, it will be treated as public. So can I make it below 50? Then it will be private. Understood?
Yes, sir.
So public offer should not be made more than 50. I cannot say I am giving to identified people of 10 lakh people I have identified and I am issuing it to them and it should be treated as private. Law says no, maximum 50 or more. Maximum, if you go 50 or more, it will be treated as public. So this is an important line. Any offer made to 50 or more in a financial year shall always be deemed to be public. Now, please tell me that if we are issuing it to public, if we are issuing it to public, how will we inform them? How will we give them all the details? Through what?
Offer document.
Through a offer document. Very, very good. So that comes with the concept of offer document. Now, offer document first require approval of whom?
SEBI.
SEBI. SEBI will go through it. SEBI will tell pay your fees, filing fees. They will specify any changes, and after you have incorporated the changes, then the final document should be given to SEBI, and that can be circulated to everyone. Before the offer document, it is called as draft offer document till it is not approved by SEBI. Concept perfectly clear?
Yes, sir.
Okay, and you have to file this offer document how many days before the opening of the issue? How many days before? It should be filed with SEBI at least 15 days before. For demat shares, who is the organization that holds securities in demat form in India? Okay, another question. Online, if I'm having demat shares, through whom I can have demat shares? There are only two.
NSDL and CDSL.
Perfect. There are two depositories only in India. Depository hold the shares in electronic form, that is NSDL and CDSL. So when I'm going to give them demat shares, I have to first make arrangement with NSDL and CDSL. Yes or no? That I am issuing online, people will subscribe online, they will buy from demat account. So that arrangement has to be done or no? I have to tell NSDL or CDSL or no that I am going to allow these services. So they will enter into arrangement with the depository for dematerialization of the securities. Clear? Then the depository will maintain all the records, and whatever record is maintained with them, they are considered to be our shareholders or investors. Now, credit rating. What do you mean by credit rating? Credit rating is an assessment by a independent agency. Yes or no?
Yes, sir.
Okay. Tell me, if a movie has got 5 stars, will you invest or no? Is it safe to invest or no? Yes. But if a movie has got 1 star, will you want to go?
No, sir.
No, because it is not good. Same way for companies also, there is a rating, there is an assessment, there is an evaluation on basis of various parameters, whether the company is good or no, whether it is financially stable or no. Some people want to take risk. If you know, people even invest in these 1-star companies. That is Warren Buffett. Okay, they used to invest. These are called as junk bonds, junk stocks, penny stocks. Nobody cares for these stocks. But still some people like to buy. Okay. Now, this is the thing. 5-star is good. Okay, a SPD shall securitize debt instruments, and unless a credit rating has been obtained from not less than 2 credit rating agencies. So I have to go to, there are different credit rating agencies. Can you all name any 1 or 2? CRISIL, ICRA. Okay, these are more than Moody. These are more than 1. So any 2 credit rating agencies you have to get yourself registered. And imagine if one gave you a bad rating. Will you mention that in your offer document or no? Only the best ones you'll take. Don't you think only the best rating should be put up and the bad ratings I should keep aside?
Yes, sir.
Yeah. So they are saying that even you can't do that. Okay, first of all, you can't do that. Even unaccepted ratings have to be put. So if I've gone to 5 credit rating agencies to take a rating, I cannot put the top 2 and finish it off. I have to put all the ratings taken from the agencies. So ideally I can take up only 2 ratings, and whatever 2 ratings are there, I'll put in the offer document. If I've taken 3, 4, whatever ratings, all ratings have to be disclosed. So think from SEBI has made these laws from investor point of view. Clear till here? Now coming to offer period. A public offer shall not remain open for more than 30 days. So the maximum offer period. Sometimes don't you think there are the discount period, Diwali offer, Independence Day offer. Are they unlimited offers, unlimited time offers, or limited?
Limited.
Here also, if you want to subscribe to the securities, they will give you maximum offer period can be 30 days. A public offer shall not remain open for more than 30 days. Minimum subscription. Minimum means minimum number of people should have subscribed. If they have not subscribed, that is what in the offer document they will mention. Generally it is 90% of the issue size. If that much people are not subscribing, that means nobody likes your offer, and then what I have to do? I have to refund the entire amount. Okay. Now, if I have to refund, it's a big loss. So normally companies keep underwriters so that if the minimum subscription is not there, that much deficit amount the underwriters will take up. Can I give misstatement? Okay. Misstatement in the offer document. I do not disclose important facts. I give false and misleading statements. Can I do that?
No, sir.
Answer is no. They've also mentioned that the officer in default will be held liable. Now, why talk only about under subscription, that people are not subscribing? Think about over subscription. Think positive. That good thing has happened and many people are interested. Then the over subscription period is there. Then I will finalize on whom I want to give in, as per the offer document, what proportional allotment to whom to give, who not to give, and it will be in consultation with the stock exchange. Then I will allot the securities to the investors within the time period. So now they've also given you the time period. In demat shares, within 5 days of closure of the offer. In case of physical form, within 8 days of closure of the offer. Concept clear? Concept clear?
Yes, sir.
Yeah. Now coming to refund. If a person, now think from the investor point of view, you think all those who are applying in an oversubscribed scenario will get the money, will get the securities?
No, sir.
No, because whenever you see IPOs and they get oversubscribed, your money gets refunded only back to you. So then the company will have to ensure that there is refunded and it should be refunded within 8 days of closure of the offer. If it is not, the officers in default will be responsible and liable to pay 15% per annum interest. Rights of investors. If I'm investing, what are my rights? My right is to know what is a trust deed shall be provided. In case of failure, if I get a shock that my money is not being redeemed, I can go up till court and at least 10% of them, okay, can call for an emergency meeting when they find that there is a default. Investors can make a motion, that is they can propose winding up of scheme, removing of a trustee or appointing of a new trustee. So this is some of my rights. Very simple, very similar to investor rights and shareholders rights. Okay, or debenture holders rights. If you read, the trustee shall take the necessary steps to carry out the resolutions. Any reasonable expenses in winding up the scheme shall be reimbursed from the asset pool. Okay, any reasonable expenses that we have done can or incurred by the trustees in winding up, obviously from where we will remove the funds, right? Asset pool. The terms of the issue shall not be adversely varied without the consent of the investors. The investors shall be deemed to have given their consent if to variation if and only if 21 days notice is given to them and it is approved by special resolution by them through postal ballot. So variation is allowed if 75%, that's special resolution has been taken and they get a proper notice. All the provisions with respect to special resolution, that is filing MGT 14, shall apply mutatis mutandis. That is, same rules will apply and you have to file the documents. Next is public issue we did, right? After making the public issue, what is the next step? Quickly. Listing. So mandatory listing is there. Okay, if you made a public issue, mandatory it is to be listed on the stock exchange. So I have to talk to the stock exchange. I have to make an application to the stock exchange to list the securities. An application will have to be made to the specified stock exchange and I have to follow the listing agreement. Can anyone tell me the listing agreement, which is the regulation for listing agreement, terms and conditions for being listed? Quickly. It's the most important regulation.
1% of amount listed security issue should be given to the...
No, my question was, for being listed on the stock exchange, which are the regulations that we have to follow? That is your SEBI LODR regulations 2015, that all listed companies have to follow those, okay, with those disclosure requirements. Concept clear? So this is called as the listing agreement, where the SPDE will enter into an agreement with the stock exchange called as a listing agreement, and that they will comply with the LODR. Concept clear? Yes or no?
Yes, sir.
Yeah. Now minimum public offering for listing. Minimum public offering for listing. So then they are giving very simple terms that each scheme, okay, was offered to public for subscription through advertisement. So each scheme, a proper advertisement should be given of at least 2 days in the newspapers, and it should be according to the offer document. You have to obtain a credit rating. In case of private placement, investors in the secondary market also should be informed, and that information should be disseminated so that secondary market players, that is, if I am there in the market, I should know that the company has given a private placement to XYZ. Yes or no?
Yes.
Yeah. And again, unaccepted rating should be disclosed. Continuous listing requirement should be there. They have to comply with the listing agreement. Compulsory listing, that minimum public shareholding of that amount as given in SEBI LODR should be maintained. Can it be traded? If obviously it is listed, it will be traded. Yes or no?
Yes, sir.
So it will be listed and traded. So in the secondary market it can be sold also. That means I have subscribed, now I want to sell off, so I'll find another investor and sell off my stake to him. So that trading is also permitted. Now we finished with public issue and listing, we finished. Now we are doing the private placement part, and for private placement they are not using the word securitized debt instruments. What word are they using? What word are they using?
Security receipts.
Security receipts. So security receipts, moment they say, you should click to you that it's a private placement to QIB. Concept clear? So
Yes,
here also there will be an issue on private placement, and after privately placing it, those security will be listed on the stock market, and then after that it can be traded. Same like before. Eligibility. Chapter 7A has been introduced. Security receipts proposed to be listed. It should be in compliance. It will be on private placement, and it should comply with the issue of security receipts conditions. First, sale of by existing holders. Tell me one thing, it's a primary issue or a secondary issue when the existing holders are selling?
It is a secondary issue.
Secondary, transfer, secondary market transaction. So when a existing holder wants to sell, so it will be investor to investor, investor to investor. So then they are saying that who propose it to sell the receipts to QIB on private placement shall be in accordance with chapter 7A. They shall be permitted only if the holding is not less than 50% of the outstanding security receipts. Such sale by any holder of security shall be permitted only if the holding is not less than 50% of the outstanding security receipts. So to whom this is allowed? Who can sell off this chapter 7A securities? If I am already holding 50% of the total security receipts, then I can knock it off to another person. After the sale, obviously they have to ensure that this is listed on the, or it has continued to be listed on the stock market. Condition for listing. What are the conditions? First, for security receipts. Security receipts are public issues or private placements?
Private.
So it is a private placement. It should be in compliance with the laws. It should not be more than 200% at a time in a financial year. Now this is for security receipts. Okay. It should be in demat form and a proper disclosure should be given. Minimum allotment should be of 10 lakh rupees. Proper valuation should be done before listing. And a credit rating agency should be, rating should be obtained, procured, availed. Offer document, very simple, same points, okay? Offer document. Now, how will you give it to the how will you privately place to the investors? Offer document, right? The same, if you go to see from public points, what we do is just going to be a repetition, because we just, instead of public issue, we are making private placement. Offer document should not be listing. It should be available for download. It can be traded. Now again, trading is also going to be in lots of 10 lakh rupees. Clear till here? Shall be issued on a private placement basis and shall be cleared and settled in the stock exchange subject to the conditions. The security receipts which have been made over the counter shall be reported to the stock exchange. Now normally transactions will be done online or offline?
Online.
But if you know, there are many collection centers where they take the application for demat also offline. Sometimes if my online system is not working, I might not have an online a bank account working, or I might want to give it through check. So all of that, they have these over the counters collection centers where I can go and apply. SEBI may specify the conditions for reporting the trades. Now streamliner, this is not important. Okay, they are just saying that for debt instruments, the listing period they have for SEBI SDI regulations, the listing was to be done in 12 working days. Now they have shrinked it to 6 working days. So let me read it out. As per the SEBI SDI regulation and all these debt regulations, it has been decided to reduce the time taken for listing after closure of the issue to 6 working days. To how much? 6 working days. Earlier it was how much? Against the present requirement of 12 working days. So can I say the time taken to be listed? Time taken for listing after closure is how many days? Is how many days?
6 days.
It is 12 days it was, but now it is 6 days. Clear? That's what they are trying to say. Next, again, this is also not important. Reduce the burden to registrar, RTAs and share transfer agents. Now to complete their activities also, they were given time, okay? Within 21 days they had to complete. So the dematerialization, transmission, etc. all these 21 days were given to RTAs to complete the transfers. But SEBI has given additional time. So let's read it. SEBI extended the time period for completion of certain activities that were brought out by RTAs within 21 days. In addition to that, the prescribed time period. So a little bit more time has been given. So not important. and SEBI has a power. Now you tell me, this paragraph is important or not important? What do you think?
Important.
Important, sir.
Very good, it is important, because it just seems like those two small boxes feels like cancelling it. Now what are they saying? They are talking of something very interesting, regulatory sandbox. Now what is a regulatory sandbox? Nowadays with invention and innovation is more or less.
More, sir.
So inventions are coming of different kinds. The payment methods have increased so drastically. Everything is becoming very technologically based. So what happened is, now you think from a tech company point of view. Now you don't have to think from SEBI point of view. You have to think from the promoter of this innovative product. Will you launch it in the market, this innovative product? And if something goes wrong, could not take the orders, there was some issue, don't you think that a lot of SEBI penalties will come on you?
So, yes, sir.
So what happens? Imagine if I am making a payment system, and in the payment system I want to test it in the market. Obviously I'll make mistakes. Obviously there will be some errors I will then have to rectify, but then you have to give me that regulatory sandbox, that kind of breather, that go play in this zone, nothing will happen to you. So SEBI might grant any person maximum 12 months to play in the market. Now this playing in the market will be in a controlled environment where I can test my product, I can test my service, I can test my business model, and if anything doesn't go as per plan, no penalty will be there on me. This kind of facility and business environment should be provided or not provided? It should be provided, because without that no innovation will take place, where the promoters will be too scared to launch anything in the market. So what SEBI has said, now obviously when I say it will be in a very controlled environment, they will see the orders and they will have those rules to even control that the public is not at risk. SEBI may exempt any person from any of the provision of these regulations for a period not exceeding 12 months for furthering innovation, for encouraging innovation in technological parts, new products, processes, services, business models in a live environment of a regulatory sandbox. Regulatory sandbox is like a sandbox where we say, okay, now tell me, have you taken children to play anytime in the garden?
Yes, yes.
So there is this sandbox and they go and play there, yes or no? There is sand and they draw up each other and play. So this is like a regulatory sandbox where the regulator is saying this is sandbox, go and play in this much environment and tell me what it is. So sandbox is a live testing environment where new products, processes, services, business models may be deployed on a limited set of eligible customers, not on full public, on a limited set of public. They might have some 80, 100, whatever, they will decide these many orders, processes to see whether it is working. The main purpose is that we can bring in innovation in the security markets, and that is it. We have completed with the entire chapter including all the past exam questions.